I'm attorney Kelly Schwab, and I work with the corporate legal department here at Bergstrom Automotive. And I'm here to talk to you today about the Bergstrom Automotive Privacy Program. The Bergstrom Automotive Privacy Program came into effect under the Gramm-Leach-Bliley Act. The Gramm-Leach-Bliley Act was instituted in 1999. At that time, it required all financial institutions to provide their customers, or in our case, guests, with a disclosure as to where their confidential guest information would be used. In 2003, the Gramm-Leach-Bliley Act was amended to include Rule P, or the Safeguards Rule. Under the Safeguards Rule, it requires financial institutions to have both a privacy program and a privacy program manager in all locations. Rule P, or the Safeguards Rule, came into effect on May 23rd of 2003. This is the time when the Bergstrom Automotive Privacy Program was instituted within our company. Violations of the Gramm-Leach-Bliley Act carry with them fines and forfeitures of $11,000 per violation. They also cover additional fines and penalties that the FTC can wage against the company that is found in violation. What this means to us as a company is that if the FTC were to come in, or if there was a complaint filed with the FTC against the company, each occurrence that is a violation of the Gramm-Leach-Bliley Act would carry with it a fine of $11,000. Thereby, if we had 5 violations cited against us, we would be required to pay a fine of $55,000. If that fine is not paid, the dealership will be locked down until such violation is paid. This also allows the FTC to become involved in the policies and procedures used in the protection of the confidential guest information. In order to fully understand what the Gramm-Leach-Bliley Act is and what the privacy program entails, you have to have a general understanding of some of the terminology within the law. The first term we're going to talk about is guest information. Guest information is a record containing non-public guest information that is obtained either by the guest or by a third party on behalf of the guest that we are handling within the dealership. Non-public information is defined as information that cannot be obtained through a public means. It also can contain lists or descriptions that are comprised of information that is non-public. An example of this would be if the company put together a list of all vehicles sold to guests in a certain year, or all guests that obtain financing or insurance upon their purchase of a vehicle. That list of guest information is going to be considered to be confidential guest information and is required to be protected under the Gramm-Leach-Bliley Act. Some examples of confidential guest information include driver's license numbers, social security numbers, account numbers, copies of driver's licenses, other financial information, credit reports, and access copies of the confidential guest information. Now we're going to talk about the Bergstrom Automotive Privacy Program and what your responsibilities and duties are thereunder. Like I said previously, under the Gramm-Leach-Bliley Act, each dealership is required to have a privacy program in place and a privacy program manager in each location. You will have an individual privacy program manager within your respective dealerships. At a corporate level, we have a corporate privacy program coordinator who is John Hogarty, who is found in the corporate legal department. If you have any questions with regard to the content of this video or any concerns with regard to violations or breaches of the program, these would be the individuals that you would contact to ask these questions of or to file your concerns or complaints with. Also, you could speak with your general manager regarding these issues as well. The objectives of the Bergstrom Automotive Privacy Program include ensuring the security and confidentiality of guest information, protecting against any anticipated threats to that guest information, and protecting against the unauthorized use of that confidential guest information that may cause harm or inconvenience to the guest. Now we're going to go through some simple rules of compliance to help you make sure that you are abiding by the terms and conditions of the program. The first one is to review the privacy program. In each of the dealerships, there is a copy of the privacy program available. This can be obtained through your privacy program manager or any of your respective managers. It's important to review those documents and look at them so you understand and any questions you have are answered with regard to your duties and obligations under the program. The next one is to not enter any restricted access areas unless you have been authorized to do so and you have a business reason to be there. Restricted access areas are designated by the restricted access or limited access signs that are posted outside those areas. You should not be in those areas unless you have a business reason to be in those areas, meaning that you are in those areas for a job-related function. You should also have been authorized by management to be in those areas for that job-related function. The next rule of compliance is to never email confidential guest information. Information of that nature should never be transmitted through email, as email is not necessarily a secure mode for transmission. If you do need to email that confidential guest information, you need to make sure that it is either a secure transmission through the third party that you're sending it to, or you need to contact corporate IT department and have them encrypt that information for you. The next one is all requests for confidential guest information must go through your privacy program manager. These would be requests for releases of information from guests in the dealership. Examples of this may include if a guest would contact you and want a copy of their purchase contract, a copy of their service history, or a copy of invoices for services provided. If you receive a request for this type of information, that information does need to be forwarded or directed to your privacy program manager. There are appropriate documents and authorizations that need to be obtained before that information is released from the dealership, and you as a team member in the dealership do not have the authority to release any confidential guest information without the authority and permission of the privacy program manager. The last rule for compliance is properly disposing of any confidential guest information. If you have any confidential guest information in your possession, it either needs to be filed into the appropriate location for that information, shred, or put into a secure shred bin. This information cannot be disposed of by throwing it into a garbage can, and this information cannot be taken out of the dealership or taken home with you for any reason. An example of this would be copies of driver's licenses. These copies need to remain in the file, or if they're no longer going to be used, they need to be shred or deposited into a shred bin. If this information is taken off of company property or is thrown into a garbage can or some other type of receptacle, that would be considered a violation of the privacy program. The next area we're going to talk about is compliance with regard to passwords. When using computers, all programs containing confidential guest information are password protected. When using your passwords, you need to make sure that you never share your passwords, you never use any other team members' passwords, that you don't post your password on or near your computer, and that you don't save your password onto the hard drive of the computer. It is imperative that you follow these rules with regard to passwords, as if there is a security breach, the company will determine the individual responsible for the breach by the password. The next area we're going to talk about is securing confidential guest information. If you leave your office or your desk, you need to make sure that all confidential guest information is put out of public view and out of public reach. This means upon leaving your desk or your office, you need to make sure that all information containing confidential guest information is either put in a drawer or put into a secure area, or your office is secure upon you leaving it. With regard to having guests in your office, if you have a guest in your office, you need to make sure that all confidential guest information is out of public view and out of public reach. If you leave a guest in your office unattended, all confidential guest information must be put into a secure area. As far as use of confidential guest information, unless you have been specifically instructed by management otherwise, you may never use confidential guest information for any purpose other than a job-related purpose. You cannot reproduce any confidential customer or guest information. You can never remove any confidential guest information from the dealership, and you can never give out any confidential guest information to third parties with regard to the information you obtain at Bergstrom. When you started your employment at Bergstrom, and on an annual basis, you have signed a confidentiality and security standards agreement. This is a contract with the company whereby you state that you will abide by these terms and conditions with regard to confidential guest information. Thereby, it is imperative that you make sure that you are in compliance with these specific rules and regulations. With regard to breaches of security, if you become aware or you feel that you have witnessed an act or something within the dealership that you feel would be a breach of this program, you do have a responsibility to notify management of this. You would notify your privacy program manager, your general manager, or the privacy program corporate coordinator, John Hogarty. If it is found that you had this information and you did not properly advise management accordingly, you could be responsible for disciplinary action. Finally, the disciplinary actions of team members. If you are found to be in violation of the privacy program, you could be subject to disciplinary action, which shall be at the sole discretion of management, which can include termination of your employment. Thereby, if you have any questions or concerns with regard to the information contained within this video, or need any further clarification or questions answered, please contact your privacy program manager or John Hogarty at the corporate legal department. Thank you.